Love, thank you for that introduction. Welcome, everybody. And I'm so glad that everyone could join us today to attend our session, which is to speak about the Accessible Canada Act. And I do also want to thank OCASI for inviting us to present with you. So as Tekla mentioned, I am a staff lawyer at Arch Disability Law Center. And I am also joined today with a law student that is working with us at Arch, Khalil Batesman, who will be co-presenting with me today. Can we go to the next slide, Khalil? So just in terms of what to expect during our session today, I'll give you a bit of a brief description as to who we are, who Arch Disability Law Center is, and what we do, just so you get a sense of what kind of work that we do. And then following that, we'll go into the details of the topic for today. We'll start off with speaking about the general principles of the Accessible Canada Act. We'll dive into a bit of the history of the Act, and then we'll get really into the regulations and standards that are made under this Act. And finally, we'll have a brief description of what to do if there's a violation of this Act. And at the very end, we do have a few minutes for any questions that you have. So if you have any questions, please feel free to put them in the Q&A box or chat box, and we will try to get to as many as we can at the end of the session. So just in terms of who Arch is, we are a specialty legal aid clinic. We work on advancing and defending the equality rights of persons with disabilities in Ontario. Arch is governed by a volunteer board of directors, and our bylaws ensure that the majority of directors identify as having a disability. And finally, just to mention that we are primarily funded by Legal Aid Ontario. Let's see the next slide. So Arch does a great number of different type of legal services within our work. Mainly, we do provide legal services to persons with disabilities in Ontario specifically. Some of those services include providing summary legal advice and referrals directly to persons with disabilities in Ontario. And that legal advice and referrals are generally within the areas of law that we practice in, which I will get to shortly. We also provide legal representation before some courts and tribunals to individuals with disabilities, and also at times we do represent organizations as well. We provide rights education presentations to persons with disabilities. We also do presentations to lawyers and paralegals, either about disability rights, but also about how to provide accessible legal services, so for their own practice. We also conduct a lot of law reform work, which is where our involvement happened with the Accessible Canada Act, which my colleague Khalil will get into a bit more in detail. And finally, we do some community development work as well. So I mentioned earlier that we do provide summary legal advice in specific areas of law. So fortunately, we can't practice in every single areas of law as it relates to disability rights, but we focus on very specific areas that are deemed to be priorities for our communities. Those areas of law are the human rights and discrimination, more specifically when it comes to accommodations at work, access to services, primary, secondary, and post-secondary education, and as well service animals and guide dogs. We also practice in the area of accessibility laws, including the Accessible Canada Act. We also provide advice and representation in attendance services, or PSW services, as it's sometimes known in Ontario. We practice in education law, specifically as it relates to students with disabilities, and if they're having some legal issues in relation to attending school or getting accommodations at school. We also practice in transportation law, and as well decision-making rights directly for persons with disabilities, which in that sense, it means either that we could assist persons with disabilities to remove an existing guardianship, or to help them with if they're having issues with the public guardian trustee if they are involved. So that was just a very brief overview about who Arch is, and if you want to know a bit more about Arch, you can visit our website or contact us. So now we'll get into really the hot topic of the day. And I will turn it over to my colleague Khalil, who will take us through the general principles of the Accessible Canada Act.
Hi, everyone. Hope everyone is doing well. Thank you for the introduction, Lila. And so, yeah, now that you have a bit of background information about us, we will get into what the Accessible Canada Act is. So what is the ACA? The ACA is a federal accessibility legislation that is still fairly new, as it came into effect in 2019. So it's only been around for a couple of years now. And what does it mean to be a federal legislation? Well, it means that the act is federal law. It means that only federal organizations are required to follow the act, and provinces or provincial organizations are not. The act was born with the goal to detect, prevent, eliminate all barriers that persons with disabilities face by the year 2040, giving it just past 20 years for the act to really make its impact. This deadline is important as it gives the agencies of which the act governs a timeline to follow to ensure that there's actual progress made in eliminating these barriers. Enlisted in the act are regulations and even smaller deadlines that work towards this large one. With the act is an introduction to a more organized approach to addressing discrimination against persons with disabilities that is accentuated greatly by imposing these deadlines, sending the message that the effort to eliminating these barriers and creating a more accommodative Canada has to be very intentional. So some important things to note in regard to this legislation would be how it defines a disability and defines the barriers they aim to eliminate. The definitions for these sort of things tend to vary depending on where you are. So what exactly is the legislation referring to when talking about a disability or a barrier? So the following definitions you'll see are taken directly from the interpretation section of the Act. It states that a disability means any impairment, including a physical, mental, intellectual, cognitive, learning, communication, or sensory impairment, or a functional limitation, whether permanent, temporary, or episodic in nature, or evident or not, that in interaction with a barrier hinders a person's full and equal participation in society. To sum it up, a disability is any impairment that when in interaction with a barrier results in unfair or unequal treatment. The Act states that a barrier means anything, including anything physical, architectural, technological, or attitudinal, anything that is based on information or communications, or anything that is the result of a policy or practice that hinders the full and equal participation in society of persons with an impairment, including a physical, mental, intellectual, cognitive, learning, communication, or sensory impairment, or a functional limitation. So to sum that up, a barrier is classified as anything that prevents a person with disability from full and equal participation. Essentially, an obstacle put in place that limits persons with disabilities in the activities they wish to partake in. Interactions with barriers occur frequently for persons with disabilities. An example of a disability, according to the Act, would be being unable to physically walk and required to use a wheelchair. An example of a barrier, according to the Act, would be the failure to install an access ramp in the entrance of a particular building, which would make it much more difficult or impossible for someone who utilizes a wheelchair to get into that building. Another example of a disability would be a person that's unable to hear, someone that is deaf. And another example would be of a barrier would be a television show being broadcasted without subtitles or closed captioning, and not allowing for persons who are not able to hear to be able to understand or know what is being said in the broadcast. The ACA also has a set of principles listed out in the Act that outline the intention and goals of the ACA. These principles are essentially the backbone of the legislation and the source of its purpose. They are as follows. Everyone should be treated with dignity. Everyone must have the same opportunities. There must be full and equal participation for all in society. There must be options available for all so that they can make their own choices freely with support if they desire. Laws, policies, programs, services, and structure must account for the different ways in which barriers and different types of discrimination intersect. Persons with disabilities must play an active role in the development of laws, policies, programs, services, and structures. And finally, accessibility standards and regulations must be made with the goal of achieving the highest level of accessibility. It is with these principles that the goals of the ACA can really be achieved and actually establish a more accessible Canada. So we know now that the Act is federal and does not apply to provinces or provincial organizations. But who does the Act actually apply to? Well, the Act applies to federal government organizations and federally regulated private organizations or businesses with 10 or more employees. This also includes organizations such as the Canadian Armed Forces and the Royal Canadian Mounted Police. Some more examples include Crown corporations, which are corporations owned by the Crown government. So companies like Canada Post. And also actual federal government departments, such as the Department of Immigration, Refugees, and Citizenship. Some examples of federally regulated private organizations would be banks or broadcasting organizations. The Act would also apply to federally regulated transportation services. This would be transportation that involves crossing over from province to province or from Canada to another country. For further clarification, buses in some contexts are federally regulated so long as you cross into another province or another country. An example of this would be OC Transpo, which is actually a city bus in Ottawa, but has some routes that cross over into Quebec, which would deem it to be federally regulated transportation. As well, there's more obvious forms of federal transportation, like via rail with trains, and Air Canada with planes and flying. And finally, federal courts or tribunals are another example of where the act would apply. So, who does the act not apply to? As I said before, these would be provincial organizations and businesses that are regulated by provincial governments. Examples of these would include post-secondary institutions and hospitals, actually, and as well as provincial and municipal organizations. There are provinces, however, that have adopted their own accessibility legislations, which would be imposed on those particular organizations if need be. Those provinces being British Columbia, Manitoba, Newfoundland, Nova Scotia, and here in Ontario, where we have the Accessibility for Ontarians with Disabilities Act, also known as the AODA. So we discussed what a barrier is, and now we want to walk you through the several types of barriers of which the Act focuses on. These barriers are particularly in 7 areas. That would be employment, built environment, information and communication technology, procurement of goods, services and facilities, the design and delivery of programs and services, and transportation. Similar to the deadlines I mentioned before, really pinpointing the areas in which the act will target makes its effect more intentional and direct. Rather than a general approach to the matter, the act outlines a broad range of categories and areas in which the act will have its impact. So we know who the act applies to and where it applies, but what does the act actually do? Well, the act is essentially a blueprint for lawmakers, government services, and businesses. It provides the guidelines in which these federal entities are to follow in implementing and creating regulations to accommodate more effectively. It also gives federal entities the power to make regulations. There are actually 3 federal government agencies with the power to make regulations: the federal government itself, the Canadian Transport Agency, and the Canadian Radio, Television, and Telecommunications Commission. They are each responsible for creating their own accessibility rules. Now, these rules are geared towards accessibility plans mostly, in the effort to ensure that appropriate measures are being taken in these particular areas. We will get into a bit more of that later in the presentation. The commencement of the Act has also resulted in the formation of new positions and an organization to assist in achieving its goals. There are 2 main positions created by the Act: the Chief Accessibility Officer and the Accessibility Commissioner. Now, the Chief Accessibility Officer acts as a sort of special advisor to the federal government, providing guidance and oversight on the progress of the ACA. This includes an annual report that the Chief Accessibility Officer must submit to the Minister for the purposes of the Act. The Accessibility Commissioner, on the other hand, promotes and enforces compliance with the Act. Complaints for violations of the Act can be filed to the Office of the Accessibility Commissioner, and they have the power to proceed with inspections, order entities to produce relevant information, and to issue compliance orders to entities that are in violation of the Act. We will get more into the enforcement of this Act later on. The organization that was created as a result of the Act is called the Canadian Accessibility Standards Development Organization, which we will call CASDO. It's also known as Accessibility Standards Canada. This is an organization that creates and develops new accessibility standards. We will touch on the difference between regulations and standards soon and get into how they are created. These new positions and organizations play a very vital role in the execution of the Act and the progress towards its goals. So, as I said before, primarily, the focus of the ACA is on the planning and reporting that goes into accessibility plans. The Act mainly sets out planning and reporting requirements on the entities to which they apply. They are as follows. Entities must prepare accessibility plans and publish them. Create a process in which people are able to provide feedback to their accessibility plans and to prepare and publish reports showing the changes that the organization has implemented and how those changes have made a difference or not. In doing so, the organizations in which the Act targets are required to take the time to construct plans that make the functioning of their operations more accommodating. The requirement that these plans then need to be published and include a way for people to comment on them drives home the idea that these organizations cannot simply implement a system that doesn't work. It will be open to scrutiny if it misses the mark and will continuously evolve in accordance to the people that voice their concern and experience these barriers. Now, I wanted to get a little bit into the history of the ACA and its origins. So, after a consultation period with Canadians from 2016 to 2017, the federal government was able to get a better insight as to what accessibility looked like to Canadians. And subsequently, the federal government introduced Bill C-81, an act to ensure a barrier-free Canada, to establish more proactive requirements, working towards this vision of accessibility amongst Canadians. The bill went through the legislative steps, starting with its first reading in June of 2018. Throughout the process, there have been several consultations and opportunities for communities to voice their concerns and comments for the legislation. The bill then received royal assent in June of 2019, meaning it successfully passed all of the stages of the legislative process, and it came into force in July of that same year. With the passing of the legislation came the stipulation that Parliament would review the Act 5 years after the first regulation had been enacted, and then every 10 years after that, to ensure that substantial progress is being made. As I said before, the goal is for Canada to be barrier-free by 2040. And so, as Lila mentioned before, Arch was actually able to play an integral role in the formation of the legislation, as we worked closely with over 90 disability rights groups to ensure the legislation would be reflective of the people to which it impacts. This collaboration included work with the Council of Canadians with Disabilities and the Accessibility for Ontarians with Disabilities Act Alliance. With their cooperation, we submitted an open letter to senators regarding the key concerns of the bill at that point and changes that needed to be made. The letter turned out to be fairly successful, as the Senate Standing Committee on Social Affairs, Science, and Technology made a number of amendments to the bill before it entered its final stages. And these amendments were reflective of the concerns addressed in the open letter. Now, I wanted to take the time to discuss the ACA's connection to human rights law. Now, it's important to note that the ACA does not provide new rights. These rights have existed and are seen in the Canadian Charter of Human Rights and Freedoms and the Canadian Human Rights Act. The Charter and the CHRA provide protection against acts of discrimination. Meanwhile, The ACA introduces a more proactive approach to these rights in the way that it governs the measures being taken by federal entities in spotting and eliminating barriers in the effort to stop or prevent these limiting interactions. The significance of these two pieces of legislation is also why, when coming across barriers, that there may be times where a human rights complaint might be the best route to take in order to address a barrier. Now, this depends on the circumstances of the situation. And we'll touch a little bit more on that later on. The Act is also in accordance with the United Nations Convention on the Rights of Persons with Disabilities. This is important to note because Canada is a state party on the same convention. And measures such as these uphold Canada's promise to the United Nations to take the appropriate measures to improve accessibility by implementing and maintaining measures such as these. Now we're going to take a dive into the regulations and standards of the Act. I'll first talk about the differences between a regulation and a standard and get more in depth breaking down each. The regulations and standards are essentially the tools of the ACA. The ACA itself creates the ideals and expectations that are bestowed upon federal organizations, but the regulations and standards provide a more direct impact on the organizations working towards the goals of the ACA. Regulations are essentially rules. They're made by the three federal entities we mentioned earlier, the Canadian government, the CTA, and the CRTC. And they tell organizations how to remove barriers. Being that regulations are rules, they must be followed. Failure to do so would result in a fine or a punishment. Standards, on the other hand, are essentially recommendations and guidelines. They're made by CASTO, the organization that was created by the ACA, as I mentioned before, and provide ways for federal organizations to improve accessibility. Unlike regulations, standards are not compulsory, and there's no punishment for not following standards. Nonetheless, they are recognized as national standards of Canada, and they contribute to the overall goal of eliminating barriers across the country. In discussing regulations further, I wanted to talk a bit about the government agencies that make these regulations. So as we said before, the federal government, the agency, and the CRTC make regulations, and they do so for their respective fields. The federal government makes regulations for government offices, regulations about how and when to make accessibility plans, and also regulations about penalties and enforcement. The CTA makes rules regarding how transportation providers make their accessibility plans and report them. And the CRTC does the same thing with radio, television, and telephone providers. As I said before, the legislation is primarily concerned with the planning, feedback, and progress reports that these entities produce that go into their accessibility planning. So these regulations are mostly rules about deadlines for accessibility plans, what they need to include, and guidelines about publishing the plans, and etc. We also wanted to draw attention to the ways in which members of the public can get involved in the formation of these regulations. There are several ways for the public to provide feedback for these regulations to ensure that they are as accommodating as they can be. The federal government and the CTA actually utilize the same process to create regulations and feature mechanisms in which individuals can provide their opinions on the regulation being put together. There are two stages in the process in which this really occurs. The first being the pre-consultation phase, where the planning for the regulation commences. This is where it's determined what the regulation should do, and what the goal of the regulation will be. Feedback from individuals can be received in the form of written documents or at meetings or teleconference calls. The potential regulations would be posted to the government or agency websites for all to find. Now, the second stage is called the pre-publication stage. This is where the public is able to provide commentary to the regulation after there has been a first draft made and the government or agency get the chance to see what people think of the new rule. Individuals have at least 30 days to formulate a response to the draft. And the drafts are typically published in Part 1 of the Canada Gazette, which is the official newspaper of the Government of Canada, and it's published every other Wednesday. You can find publications of the Gazette on the federal government website. The CTA also requests individuals to provide feedback through its Accessibility Advisory Committee. This is typically done through meetings and questions. Now, the CRTC offers a similar setup in that there's a policy-making stage where people are asked to provide written input and publish those contributions for others to comment. After that, individuals are given the opportunity to comment on drafted regulation. People will typically do this in the form of letters. It's important to note that in the event that any of these regulations from any agency in process are difficult to access, you can request from the specific agency to provide further accommodation. We have included here links in which you can find these regulations for these respective agencies. They're all each on their respective government websites. Now, getting back to the standards and going a bit more in depth with those. In creating standards, CASTO is governed by the philosophy, nothing without us. This being the overarching sort of theme of CASTO's work, the knowledge and opinions and experiences of persons with disabilities are highly regarded. Essentially, none of the initiatives or measures being taken hold any weight without the input of these communities. CASDO holds that research and input from persons with disabilities are vital for the process. At least 30% of technical committees, which are groups of individuals formed to provide input and develop standards on certain areas, are made up of individuals with disabilities. CASDO also makes sure that the consultations for these standards are public and accessible to ensure full participation. Here we have listed the process for which standards are created by CASDO. They're as follows. A technical committee is formed for discussion about a particular area, such as employment. Meetings are held to develop a standard applicable. The public gives its feedback to the standard, and then it receives further revision. And then it is published. As I said before, standards are guidelines and are not compulsory. However, they do have the potential to turn into regulations in the event that CASDO asks the government to. More specifically, asking the Minister of Diversity, Inclusion, and Persons with Disabilities. Here I have an example of a standard that was created by CASDO in collaboration with the Canadian Standards Association Group. It's about an 80-page document outlining the ways in which organizations can make self-service interactive devices more accessible for persons with disabilities. One can check the list for standards that are still under development and available for public comment on the CASDO site. For example, there's an employment standard that has been put up for public review and comment, and it's up there until the end of this month. Now here we want to address a bit of what one might do in the event that they come across an accessibility barrier. If one were to file a complaint about the barrier, who they would go to depends on who the complaint is against or which field it relates to. If the complaint is against a federal organization, your complaint will go to the Accessibility Commissioner. This is outlined under Section 94 of the ACA. A formal complaint may be filed, after which the Commissioner can commence an investigation into the claim and use its powers to enforce the act if they find the claims are substantiated. If your complaint is regarding federal transportation, then your complaint will go to the Canadian Transportation Agency, likely. If your complaint is regarding radio, television, internet, or phone companies, your complaint would go to the CRTC. As mentioned before, complaints at times can be brought to the Canadian Human Rights Commission. In the event that they pertain to these particular locations, and a complaint through the ACA is the best way to proceed. In circumstances such as these, it is best to seek legal advice on how to proceed. Sorry, forgot to switch over to the next slide. Sorry, guys. So yeah, now we have time for any questions that you may have. Thank you guys for listening.
Thank you, Khalil. Just before that, can you just go back to the last slide?
Oh, sorry. Yeah. So, summing up. Yeah. Sorry about that.
So,
yes.
Just to kind of sum up a little bit what we were talking about today about the Accessible Canada Act. I know there was a lot of information that was provided to you all, and it's a lot to really keep in mind. But really what it comes down to for you to all remember is that the Accessible Canada Act is a federal legislation, and it's specifically related to accessibility. And because it's a federal legislation, it has very limited application. It applies only to federally regulated organizations, whether that's public organizations or private organizations, as Khalil had mentioned earlier on in the presentation. And another important point to keep in mind about the Accessible Canada Act is that it is governed by several principles, and that those principles really are what guides the entities and the agencies and the federal government to really enhance and ensure that Canada becomes a barrier-free country by 2040. And with those principles also in mind, there's also specific barriers or specific areas that the Accessible Canada Act focuses on. We had them listed earlier, but the Act really, although there are many, many different areas that needs to be focused on, the Act does say, listen, let's focus on these 7 areas at this time. And in those 7 areas, the Act does prioritize to identify, remove, and prevent any barriers to accessibility. Another important point to keep in mind about this Act is that it's essentially its goal. And its goal is to make Canada barrier-free by 2040. Seems to be essentially a bit less than 20 years now, but it is fast approaching. And that is stated as a deadline in the Act. It remains to be seen what happens from now to 2040. And finally, from the Act, there are the regulations and the standards that are created as a result. So regulations are specifically a set of rules that are mandatory for all federal entities to follow. And it is related really to how these entities, or what these entities must do to ensure that they are removing and preventing barriers to accessibility. Regulations are mandatory. There are actually consequences if they are not being followed. On the flip side, standards are also created from, or come into fruition from because of the act, but they're created by CASDO, and they are not necessarily mandatory, but they are voluntary, meaning that entities do not necessarily have to abide by the standards. However, these standards are guidelines, they are recommendations for entities in order to guide them in ways that they can, or manners that they can use in order to be able to remove and prevent any barriers to accessibilities. So they are kind of strong recommendations, but unfortunately there is no consequence or no legal consequence if they're not followed. And finally, if there is any violations of the Accessible Canada Act, there are complaint mechanisms in place for individuals to file complaints about any violations or any barriers that they experience when interacting or trying to access any of the federally regulated entities or organizations. The different complaint mechanism depends, as Khalil mentioned, depends on where the barrier was experienced, what was the agency or entity that created that barrier or that still has that barrier. So it could either be with the Accessibility Commissioner, it could be with the Canadian Transportation Agency, it could be with the CRTC, or in some cases, it could even be a human rights complaint at the CHRC, the Canadian Human Rights Commission. It's very difficult for us to say exactly which situation would apply when, just because it does depend a lot on the very specific situation that the person is in and the specific facts of their experience. So if you have a complaint or if you faced a barrier when accessing or trying to access a federal organization and you want to make a complaint, it's best to seek legal advice about your rights and where would be the best option to file the complaint. So these are really just important, the important points, or really the main points, I should say, for you to keep in mind as what the Accessible Canada Act is and what it can do and what it cannot do. So I do thank you all for listening to our presentation. We do have some time now for some questions. And I know that there was quite a few that came up during the presentation in the chat box at the Q&A. So we could try to get through as many as we can. And if anyone has any other questions, please feel free to let us know, and we'll go through as many as we can. Thank you. So I could start off with one of them, one of the questions that came in through the chat. And I will try to go in order, and I hope I don't miss any of the questions, but one question was, let me just find it again here. How can the Accessible Canada Act, as a federal act, have teeth for Canadian residents when we are not interacting with something within the federal domain? This is a great question. Um, and uh, what I would answer, and Phil, please feel free to jump in as well. Um, what I would answer to this is that essentially the Accessible Canada Act can only applies to the federal domain, um, federal organizations. So anything, any interactions that has to do with a provincially regulated organization or municipal organization would not be covered under the Accessible Canada Act. Now, having said that, there may be other forms that you could go through if you are experiencing either discrimination or a barrier to accessibility with an organization that is provincial or municipal. Depends on which province you're in, but I can say in Ontario specifically, there is a human rights tribunal in Ontario specifically that can deal with complaints about discrimination or accommodations or lack of accommodations due to disability in specific areas, in specific social areas, which is called the Human Rights Tribunal of Ontario. And I know that it's not necessarily directly linked to accessibility necessarily, but there are, in most situations, if you are experiencing a barrier to accessibility when accessing an organization or communicating with an organization, for example, a lot of times uh, that could be argued as a case of discrimination, and that would fall under the human rights legislation in Ontario. Then you can make a complaint at the Human Rights Tribunal of Ontario. And in Ontario specifically, there is also, as Khalil had mentioned earlier, on the AODA, which is the accessibility legislation for Ontario. So the government of Ontario had enacted many years ago its own accessibility law, and that really only covers provincial organizations. Now, however, having said that, the AODA does not necessarily have much of a complaint mechanism in place. You could make a complaint with the provincial ministry, but it's not as detailed as the Accessible Canada Act, which is why, generally speaking, when you are facing these kind of barriers to accessibility and you're directly impacted by that barrier, many times it would be a case of a human rights complaint at the Human Rights Tribunal of Ontario. However, regardless whether one situation or the other, I do still also strongly suggest that you always get some legal advice on your particular situation. I hope that answered that question, but please feel free for that person, please feel free if you will have any follow-ups to what I just mentioned. Just going through here. So I have another question here from the chat that asks why 2040 as a deadline from the ACA. The comments also states that seems that people with disabilities are certainly being put on the back burner. And why did it take so long to be implemented since the American Disability Act is over 30 years old? To be honest, I wish I had an answer for that as to why it took so long. to get to where we are. Unfortunately, I do not know why it took so long. Could just give you my best guess but would be more of an opinion, that, I don't know if it's politics or any of the sort, to be completely honest. But I'm not entirely sure why it took all the way till 2019 to actually have this set up. And furthermore, there is still, honestly, there's still a lot of work to be done as well as a result of the Accessible Canada Act. The act is in force. There are already quite a few regulations in force, but the standards are still being developed. And so there is still a lot of work to be done, even though the standards are voluntary. They do provide a lot more specifics as to how entities can remove barriers to accessibility. Why 2040? It just seems that's the, they gave themselves, or the federal government really gave themselves about 20 years to do so. Can't really say why. I can't really answer as to why they chose 20 years, unless, Khalil, I just saw you.
Yeah, no, as I was doing research into the act, I was thinking of the same thing. I was wondering why specifically 2040 would be the marker. Wasn't very clear, but based off of, looking at other legislations and the many deadlines that they have within this legislation for each organization to put in place at a certain time. It's just, as I said before, I believe it's all a part of being more intentional with addressing these barriers. Having that deadline sort of puts it in people's heads, or these federal entities' heads, that this needs to be done and this needs to be done now. 20 years is not that long in the grand scheme of things, in making Canada completely accessible. So, I believe they put a general number out there and they're going to work towards it. Will it be done by 2040? That's a great question, but I believe it's very important to have deadlines like that in place so people can sort of take it seriously.
Right. Oh, great. Thanks, Khalil, for that additional tidbit as well. So just going back to the Q&A. So I have one question here. Do the business of 10 or more need to be federally regulated? Oh, and I just noticed that there's another message that that person said, no worries, they saw the answer. But I'll still repeat it just in case anyone else has missed it. So essentially, the answer is yes. Any business, any of the federally regulated businesses of 10 or more employees, to be captured under the Accessible Canada Act, they have to be federal or federally regulated. So again, we're making that distinction between a provincially regulated private business versus a federally regulated business. I have another question here. How about the movies? Will they be required to have captions in the theater? So that's a very interesting question as well. Essentially, movie theaters are generally actually provincially regulated as a provincial business or company. So, for example, if I take the example of Cineplex in Ontario, Cineplex itself would have to ensure that in Ontario, they have captioning available for their movies. So I would, there's no actual direct answer from the Accessible Canada Act, but just based on my general understanding of the entertainment area or business area, is that since theaters are regulated by provincial laws, then if you do require captioning in the theater to watch the movie, that is an accommodation that the movie theater would have to provide specifically and directly. So that would be, again, fall under provincial legislation as opposed to the Accessible Canada Act. The next question here is, as a disability activist, how can we make sure this act is applying? It's a great question. So there are different ways. One, there are different actors that are, or different departments are also in charge of ensuring that the act is being applied and is being followed, such as the accessibility commissioner. But as an activist or even an advocate as well, or an individual, right? There are ways that you could make complaints to the accessibility commissioner, for example, or the CTA or CRTC, depending on the context, if there is a barrier that you're experiencing when, or you realize that the organization you're dealing with is not following the Accessible Canada Act. And that will be done through the complaint process with either the Accessibility Commissioner or the CTA or the CRTC, depending again on who is not abiding by the act.
If I can chip in a little bit, yeah, like much to the sentiment of what you were saying, just sort of, I believe the spirit of the ACA is to be a very active participant in its, well, we were as in its formation, but as well as progression, to ensure that these goals are being met. They are really calling for people to step up and play a role in voicing their opinions on the matter. So it's very important actually to, when you see barriers, like Lila said, to ensure that the complaints go to the right place. And as well, as I mentioned before in the presentation, to play a role in the formation of these regulations and standards, right? Like there are forums in which and processes in place where we want the public to sort of voice their opinions on what needs to be done further. I think that's the whole essence of it. It's a sort of collaborative project. We need the people who it affects voice on the matter. And as well as even if you're an activist, just to be aware of what other people may need as well. Voicing that concern when you see a barrier as such, and playing a role in the planning and formation of more regulations and standards is a huge role in the ACA, and that's a big way as well. We'll see Canada become more accessible.
Thank you, Quill. Are there any job opportunities in this field? I think if you are referring to with the creation of the standards or regulations, or if you are referring to something else, I'm not entirely sure. But so of course people could get very much involved in different ways, as Bill had mentioned several few times during the presentation. So you could provide, your feedback with when they're drafting regulation. We can also be involved more substantially and more directly with when they are creating the standards. So CASDO does create these technical committees where these committees are involved in really the drafting of the standards. I believe there is a very robust selection criteria and process for anyone who wants to be a part of those committees. So I would probably suggest that maybe you visit their website, and we had the same link that we had provided about where you could find the standards, where they detail exactly how you could get involved in that process. In terms of job opportunities with the disability commissioner or otherwise, I'm not necessarily aware of specific job opportunities, but I can probably only assume that there is at some point. You would probably need to contact the accessibility commissioner directly if they have any opportunities there or currently. Yeah, Khalil, you want to add something?
No, Lila, yeah. Looking into the act a bit, it's briefly I saw there were jobs related to the ACA in the sense that there are just more so just government jobs, and there's a lot of government workers working on this. So if you look towards the federal government, there's quite a few opportunities in regards to legislative opportunities and keeping the act together. But there wasn't too many I saw in terms of, I don't know, like for standards, for example. I know that they take a lot of volunteers to go on that technical committee, but in terms of financial compensation, I don't believe so. But yeah, if you're looking for an opportunity, it would be mostly geared towards the federal side, I believe. A lot of the roles, I believe, have been filled because it's been formulated already. But I'm sure there's a lot of opportunities in the maintaining of the legislation, and there's opportunities in the accessibility commissioner's office, for example, and the chief accessibility office. So yeah, I'm sure there's opportunities there as well. But yeah.
So our next question here we have, may we have a description of how the ACA interacts with the AODA? So the AODA, as a reminder, I know some people may not be from Ontario, that's the accessibility legislation in Ontario. So essentially, the ACA and the AODA are two very separate pieces of legislation. They, while they have similar goals in the sense of removing barriers to accessibility, they don't apply to the same types of organizations. The ACA is strictly for federally regulated organizations, whereas the AODA is specifically for organizations regulated by the province of Ontario. So I can't, unless Killa, you have an example in your mind, but I can't think of
Yeah.
any organization where both would be necessarily captured by both the ACA and the AODA. They are very separate in that sense.
No, Lila, like you're right, you're spot on. I don't believe they intersect. It's more so, it's sort of the AODA represents provinces taking those further steps. Hopefully, all provinces and territories follow the same direction. But the AODA is only in regards to federally regulated organizations and businesses, and then the AODA comes in and regulates provincial businesses and provincial entities. So it's sort of like a not a backup, but it's another option that someone can utilize in the cases the ACA that does not apply. So they both help each other, but they don't really directly interact. No, I wouldn't say that.
So what would an example of a complaint that you would take to the Human Rights Commission over the ACA's accessibility commissioner, even if it was a federally regulated organization? That's a very good question. I think I'm not entirely sure if we can fully know of a situation where it would be specifically one or the other than the fact maybe that we want to make arguments specifically related to the Canadian Human Rights Act, and not necessarily bring in the ACA as a basis for your complaint. And in that case, it would go to the Human Rights Commission. I'm trying to think here of maybe a potential example when one would go to the commission and not necessarily the ACA. And this is the only one I could think of, and it may or may not be completely black and white, but a black and white situation. But the only thing I can think of is potentially a case where a person who is employed in a federally regulated organization and they're not receiving specific accommodations for them, for their disability needs, then perhaps that would be a situation where it would be best to go to the Human Rights Commission as opposed to the Accessibility Commissioner. I think that might be the clearest example I could think of off the top of my head. But again, I think it remains to be seen how the case law will interpret these two roles. Because I think it's still early on in terms of making a clear distinction between the two at this point. So yeah, the only thing I could think of is maybe a direct situation where maybe it's a lack of accommodations, a specific disability related needs of an employee, maybe best to go to the Human Rights Commission as opposed to the Accessibility Commissioner. But having said that, again, any situation that you are facing I would strongly suggest again to get legal advice on the specifics of your case, of your situation. There wouldn't be necessarily a one answer fits all, unfortunately. So next question, with the aim to make Canada barrier-free by 2040, with its limited application, how would this act make that happen? Entities that are not federal are not obligated by this act. Seems the goal of a barrier-free Canada overstates its authority. I can definitely understand what the meaning behind that question is, and I can really agree that in some, like, saying Canada will be a barrier-free may definitely seem like an overstatement of the reality of what this act does or will do or what it's supposed to result in. Simply being, I mean, the Accessible Canada Act is limited. It's absolutely right. It's limited to just specifically federal entities. And there are some provinces that have also, they've enacted their own provincial accessibility laws, which would make that province as well barrier-free, or with the goal of being barrier-free, in addition to the federal entities. But unfortunately, because of the way that Canada's laws and regulations and division of power that we have in Canada makes it that any laws or most laws from the federal government may not necessarily always be able to be applicable to provincially regulated organizations. And that's where the Accessible Canada Act can only apply to federal entities. I'm not, maybe, I mean, it may have been too wordy to say to make federally regulated organizations barrier-free, but unfortunately, that's the limits of the act. I know that the AODA, they have their own goal of making Ontario barrier-free, which is actually coming up. I believe it's 2025. At least that's what stated in the legislation. It's only about a year and a half, or less than a year and a half away. But definitely, I can completely understand your statement about that. The fact that the goal of the Accessible Canada Act may seem like it's overstating in terms of wouldn't be necessarily Canada as a whole, as in everything in the country will be barrier-free, but really just the limited federally regulated organizations.
If I come in a little bit on that, Lila. I think it's a great question, Kelly. So it really got me thinking. I believe it is sort of an overstatement, like based off of what you pointed out. It's being that not all provinces are able to be sort of regulated in that manner as yet. But I believe with the large scope of which the act covers, because it does cover quite a lot in those three sort of agencies. It's the hope that provinces will follow suit of other provinces, and that by 2040 at least, the effect of the ACA on those federal entities will be substantial, and that will sort of bleed over into other areas that are sort of slow to catch up. And by then, we'll see those changes. But yeah, you're right. Like it's unless that those provinces sort of catch up to speed soon, it is a bit of an overstatement. But once again, it covers a broad range of things, and it's the hope that the impact will be a great impact will be felt regardless at the end of the day.
Thank you for adding that. Next question here is, if barriers are identified that can be addressed by a publicly regulated body like transportation, do they have to address the barrier when identified, or can they wait until actually addressing the barrier up until 2039? That's a great question. Essentially, there are, and Claude could probably go into a bit more details. This was touched on very briefly earlier in the presentation, but they do, so any publicly regulated or federally regulated body, whether public or private, they do have some very specific timelines for them to do certain things, such as some their accessibility plans, and they do have the obligation as well to prepare and submit progress reports as they are going. And and in that way can hopefully address the potential concern that an organization would just wait till the very last year to address anything or any barrier that they encounter that they already know about. So they do have those obligations, those ongoing obligations as time goes on. So is there anything you want to add to that?
No, it's a great question. I just wanted to add that, although the act has that sort of deadline, to encourage entities to get up to speed, it is also stipulated in under the interpretation section that while these there are deadlines and such, and a little bit of room to play with, but it's encouraged that these barriers are eliminated as soon as reasonably possible. So it's not to sort of hinder an organization's ability to, uh, make sales or do exactly what the organization does. But as long as it's reasonably possible to do so, it should be done as soon as possible. Rather, it's not wait up until 2040. Like if a barrier is pointed out and it's brought to your attention, you need to take the steps to eliminate it as reasonably as fast as can be.
I have another question here that states, how can we make it inclusive and address accessible act as a whole together and better? Some provinces and territories are in crisis for housing and mental health. I'm not entirely sure. I hope I understand the question correctly. And if not, Noah, you can clarify it for me, perhaps. What I understand from the question is that you're asking if there is a way to use the Accessible Canada Act to deal with the housing crisis and mental health crisis, if that's what I'm understanding. Please let me know if that's not it, but essentially, again, the Accessible Canada Act specifically is, focused on 7 areas in terms of identifying, removing, and preventing barriers in those 7 areas that we have mentioned. So, whether or not the Accessible Canada Act can be used to assist in current issues such as housing and mental health it's a little unclear to me, just in terms of it depends on whether or not there is anything for a federally regulated entity to have a role in addressing those accessibility issues that are present in those specific areas. There are standards that are still being developed that to cover many areas or sub areas to really address accessibility issues in different aspects. So, for example, if I could say for if housing, maybe if it's related to an area, housing in a that's run by a federally regulated organization, and there are some barriers in terms of accessibility for persons with disabilities or related to that federally regulated housing, then perhaps that could be a way that the Accessible Canada Act could be helpful. There may be, I think my one suggestion would be to keep track of what standards are being developed. There is a list of ongoing standards on the CASDO website. And there are opportunities, as Will had mentioned, to provide your feedback to CASTO so that they can improve those standards in order to be able to address specific issues related to accessibility that the standards may, or the first draft of the standard may have missed at some point. And there are, they do provide for some time for people to provide that kind of feedback, so that CASTO can then take into consideration, what your comments are, and what needs to be added to the standards, to a specific applicable standards in order to straighten it in that sense. Chloe, is there anything you would like to add?
No, not much. Like you said, if it sounds like the certain areas that you are discussing, not 100% sure if they would fall under the federal scope, unfortunately. And like I said before, it's with the hope that a lot of these provinces can follow suit behind like Ontario, British Columbia, and develop their own provincial legislations to better address these particular situations and these particular crises that you mentioned. But as of how the Accessible Canada Act can sort of help with those situations, it's a little bit unclear, unfortunately. It's the act sort of outlines where its effect will be felt, and it's sort of limited in that sense. Although sort of broad, there are going to be situations where it falls a little bit short.
Just going down, I think we just have see a couple more questions. So I think we're still good on time. So hopefully I'll be able to get to all of them for the end of the session. So the next question that we have here in the Q&A was, a person with a disability leaves his partner and gets pregnant. There's no official marriage act between them. So what to do as a legal action against a person with disability regarding financial or other support? This type of situation actually would not be covered by the Accessible Canada Act. This would be more of a family law situation where that person referred to in the question would need to speak with a family law lawyer specifically about getting financial or support, since it's a situation between two individuals. So the Accessible Canada Act is really about really more so about the organizations and entities to ensure that they are removing barriers to accessibility for individuals with disabilities. And I had another question that was forwarded from the chat. If federal funds go to provinces or municipalities, will there need to be compliance because of the legislation? So that's a great question. So essentially, for the most part, the fact that a province or municipality is receiving federal funds does not necessarily make whatever fund that province or that those funds are going to assume a specific department or organization in the province or municipality doesn't necessarily render it automatically a federally regulated entity. More specifically, the Accessible Canada Act actually does make a very, very detailed list of what is considered a federally regulated entity and what would be covered by the Accessible Canada Act. So it's not just the fact of having a provincial organization or municipality receiving funds from the federal government that would make it automatically a situation where it becomes federally regulated necessarily, right? It has to fall into one of the categories or one of the very specific lists that is in the Accessible Canada Act itself. And I believe I had one more question. Tekla, do we have time for one last question?
Okay, but also we'll be running the polls as you do the last question.
Okay, sure. All right, so this is just the very, very last one. So with also something where it was across multiple axes of human rights, like a trans disabled person getting denied access to a bathroom in a federal building, and it isn't clear that it is covered by the ACA. So if I understand, you're asking if someone being denied access to a bathroom in a federal building as a trans disabled person, would that situation be covered by the ACA? So the ACA is really about barriers for related to disability. So being denied access to the bathroom in a federal building, just in general, would be, in my opinion, would be covered by the ACA in terms of accessibility or an accessible bathroom, right? As I think if I understand the question correctly, and please correct me if I'm not answering it or if I'm not understanding it, if you're asking about the fact that it's a trans disabled person being denied access to a bathroom for reasons other than disability, whether it would be covered by the ACA, then you would not necessarily, because the ACA is very, very much focused on, or specifically focused on accessibility for reasons of disability, as opposed to any other grounds that may be related to a person's identity. However, having said that, that doesn't necessarily mean that there would not be any recourse. Whether if it's not covered by the ACA, there's also complaints at the Human Rights Commission, human rights complaint that could be brought as well.
Okay, thank you so much.
I think that was all the questions. I was just making sure I haven't missed any questions.
Yeah, thank you so much. Maybe if you want to share maybe your contacts for maybe additional questions, then maybe we can do that because of time.
Yeah, absolutely.
I really thank you so much, ACT team. And we really, for me, it was really an informative event. So we really hope the information that we shared here today will be able to adapt some of those things and also put them into practice. It really magnified our understanding and perception of the Act. So with that, please complete the evaluation that is, the link is in the chat, and also I will send out on emails. And I will also share out the presentation that was shared so that maybe you can get the contacts there. Thank you so much.
Thank you, everybody.
Thank you.
Thank you so much for having us. Thanks.
Okay.